That's why the second proviso deals with the mechanism under the rules
Yes.
inbuilt for the purpose of ousting him.
But
You're not wrong.
no, but the first volume.
Why you apprehending at the moment? Incident has come forward before.
We are
I'll tell
concerned.
you, Gopal,
Is-
keep one thing in mind.
Yes, saying that free and fair elections is a part of the basic structure, democracy is a facet of that, but saying you can't test statutes on the basic structure. Then Manoj, Krishnamurthy, it's not in the compilation. Krishnamurthy is 2015, 3 SEC 467. This is a situation where a affidavit, which was required under earlier your lordship's judgment, had to be filed by the candidate and he had failed to do it or suppressed. The question was whether this amounts to a corrupt practice. This is 2015, 3 SEC 467. I'll just read two paras from it, 12 and 13. Now. I'll read particularly para 13, Manoj. Para 13 is at page 480. To answer the said question, it referred to, this is referring to Association for Democratic Reform. It referred to the authorities in Vineet Narayan, Kehoto, Holahan, and opined that in case when the act or rules are silent on a particular subject and the authority implementing the same has constitutional or statutory power to implement it, the court can necessarily issue directions or orders on said subject to fill the vacuum or void till the suitable law is enacted. That one of the basic structures of our constitution is republican and democratic form of government, and therefore the superintendent's direction and control of the conduct of all elections to parliament and to the legislature of every state vests in the election commission. And the phrase conduct of elections is held to be of wide amplitude, which would include power to make all necessary provisions for conducting free and fair elections. Both of these judgments then reiterate across a span of nearly 40 years the fact that free and fair elections, democracy, etc. are part of the basic features. It's reiterated in the Scora judgment, that's 2016, 5 SEC, page 1. Yes.
Part of the issue. It has to be fair and absolutely.
No, this particular para I read because it mentions the election commission's role.
It's correct.
So one is the value. The second is the entity who enforces that value. Independence of judiciary enforced by Supreme Court. Therefore, appointment system becomes important. Free and fair elections, democracy ensured by election commission. Therefore, appointment to the election commission becomes important. I'm sorry if I'm berating, I'm just reiterating that point too often. So I'll stop with that one. Therefore, my submission on the first one is complete. Second, coming back to Article 324. No, I'll give the parasite. Coming back to Article 324 and the question of the protection that has to be given. This is Article 324, subclause 5. If I can trouble your lordship with reading this, because there are two provisos. And the interplay of those provisos is something which I believe is not an argument made in the Session matter. So the observations that Sessions judgment made was only to reconsider the decision in Danoa as to whether the CEC was in any way in a preeminent position over the other election commissioners, or is he on par? The argument made in Session was, look, he is obviously very different because he has the power of recommending the removal of the other election commissioners. The court rejected that and said, yes, there may be a difference here, but on all these other things, you can see parity, including the 1991 Act. Therefore, the CEC and the election commissioners are on par, something that at that time the petitioner, Mr. Session, did not want. Now, taking off from that point, the question now before your lordships, apropos of the first prayer in my writ petition, is the process of removal which applies to the CEC, does that same process of removal apply to the election commission? On first blush, it appears it doesn't. In fact, the judgment in session, without going into that question, merely recognizes that there is a difference. It doesn't say how it's different, but it says that it's different. The reason, my lords, if your lordship will see 324 subclause
goes on to provide the additional safeguard of declaring the law to be removed. That though they can be removed on the recommendation of the CEC,
yes,
there should exist real, reason.
Reason, absolutely.
So all those have been explained.
Correct, correct.
And the distinction has been sort of cast in stone.
So I'll just cut to the quick and tell you, your lordship, what my argument. My argument is, because of the language employed in 324(5), the additional procedural requirement which is provided in that proviso is that there will be a recommendation from the CEC.
Correct.
You will not remove the subordinate without at least a go by as far as the person in charge is concerned.
Correct.
That's all it does.
Correct.
My interpretation is that the same process of removal is required for both CEC and the EC. Same process. And that, I believe, flows from the language of the provision. If I can read that for now.
Causes omissions.
I would say causes omissions would apply in a situation where there might be an ambiguity regarding it. I'll just read this to your lordship and then I will examine, my lord, whether there is such an ambiguity. 324(5) says, subject to the provisions of any law made by Parliament, the conditions of service and tenure of office of the election commissioners and the regional of the election commissioners and the regional commissioners shall be such as the president may by rule determine. No quarrel up to here. There's a colon there, after which proviso, first proviso, provided that the chief election commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court, and the conditions of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. I'm pausing for a minute. Two parts here. The CEC can only be impeached, and B, you cannot change his conditions of appointment to his disadvantage. Two parts. Proceeding further, provided further that any other election commissioner or a regional commissioner shall not be removed from office except on the recommendation of the chief election commissioner. Two possible interpretations. One, which is the one which appeared to be the one that's argued in session, is to say chief election commissioner impeachment, election commissioner just show him the door once there's a recommendation from the CEC. So it virtually becomes summary, no procedure, nothing like that. What I'm arguing is the main proviso says two things. It says that the CEC shall not be removed except by process of impeachment, and that his conditions of service shall not be varied to his disadvantage after the appointment. The reason why they mention only the CEC is because the Constitution provides really only the CEC. The EC is at discretion.
If any.
So, if any, absolutely, I'm grateful. It uses the words if any. So, if the EC is not appointed, it would be perhaps superfluous and unnecessary for them to provide separately. But once the EC is there a possibility that when they start the first proviso with two parts, that neither of them will apply to the second proviso? I ask myself this question because if that reading were to be followed, that would mean that the election commissioner's conditions of service could be changed to his disadvantage. You can't do it for boss, but you can do it for subordinate. My interpretation is those two things continue to apply. They will apply to the election commissioners, but with the additional procedural safeguard that you ask boss. Can we proceed against?
Why you are asking this question at the moment?
The reason is my prayer in my writ petition is that the same process of removal has to apply to to the election commissioner so that they can act independently.
Tell you one thing.
Yes,
Please go through once again.
yes,
If you will see clause 2,
yes, ma'am.
it refers to chief election commissioner and election commissioner.
Yes,
So this mechanism of appointment is covered by clause 2.
yes. But it says if any, as far as election commissioner.
Correct. Now if you come to 4,
Yes,
this deals with the mechanism and you turn over the page, election commission,
yes,
accordance with so and so.
yes,
5 refers to the condition of service of election commissioner,
yes,
nothing to do with chief election commissioner.
yes,
If you see in 5, subject to the provisions of any law made by the parliament,
yes,
the condition of service and tenure of the election commissioners
yes,
and the regional commissioners,
yes, ma'am.
as per the rule.
Yes,
Now that will determine
yes,
the mechanism in ousting the election commissioner refers to the further proviso. Second, the first proviso refers to clause 5 is absolutely clear, chief election.
I'm sorry, clause 5 is dealing with conditions of service and tenure of election commissioners and regional commissioners.
Not chief election commissioner.
It doesn't say so.
Yes.
It doesn't say so.
Now, if you look at the proviso,
No, but the
Provisos.
1991 Act does. It deals with the chief election commissioner.
first proviso deals with the ousting of a chief election commissioner.
Yes,
Then second proviso, since the substantive clause 5
yes,
refers to rules
yes,
for election commissioners,
yes,
that's why the second proviso deals with the mechanism under the rules
yes.
inbuilt for the purpose of ousting him.
But
You're not wrong.
no, but
The chief election commissioner mechanism is different. It is the mandate of the constitution itself interprets independently.
no, the problem is it says conditions of service and tenure.
Condition service covers all.
It should, but since the 1991 Act, which is made under this clause 5,
Yes.
doesn't deal with removal at all.
That's for whom? Election commissioners.
Yes, it doesn't deal with removal for anybody. Your Lordship may just take that. That's the first volume.
Why you are apprehending at the moment? An incident has come forward before you.
No, no.
Let me ask something. Ever come across any incident ever happened where this
reason
power
why-
available has been misused arbitrarily by any authority?
It's not that, no. It's about, and I'm sure the AG will also support me on this.
AG is not responsible.
No, on the interpretation, I'm sorry, on the interpretation.
Okay.
The interpretation of the government at the moment, and which is what the apprehension is as far as we are
Can
concerned.
you, Gopal,
Is-
keep one thing in mind.
Yes,
To see service jurisprudence,
yes, ma'am.
take the order of suspension.
Yes,
The appointing authority holds absolute power
yes,
to place under suspension.
yes,
And he's not supposed to assign reasons also for suspension, contemplation.
yes,
Number of times arguments are advanced before this court. This is an absolute arbitrary discretion vests with authority. And you may call on legal framework, it's not any kind of a stigmatic, but it's social stigma.
yes,
Social stigma is there, which the
Yes.
man carry who is under suspension.
yes,
But this court has always come forward
yes,
that merely because the power vests with authority to exercise in a given facts and circumstances, court may struck down the order. But to say that the authority is power vested in exercise under the constitution in the instant case can't be regulated by any election mechanism. Unless we find,
yes,
like you are before us,
yes,
that time has come, the manner in which chief election commissions are been working,
yes,
people have different kind of their own perceptions. Now you are taking a call
yes.
to this court to step in and lay down the guidelines.
No, I'll explain what the
Why
problem is.
you have come? You have come.
I'll explain.
You have come here. They look here. What is going on with ground realities?
I'll explain.
Please step in
No, I'll explain.
and lay down the guidelines
No, I'm sorry.
in place so that the people should know what is the mechanism adopted by the government appointment.
I should have been clearer. This is not like a service matter. This
No,
is
you're right.
because I know the reason why we're here is threefold, and I'll tell you Roger what that is. First, you have a judgment in session where the argument is taken and accepted that the process for removal of the CEC as versus the ECs are different. The process of removal is different. We have that counter affidavit of the election commission with all the correspondence where they say, please ensure that the process of removal of CECs and ECs are put on par. Repeated letters. Even the law commission considers this. The ubiquitous view, and this is why I believe even the AG joins this, is that at the moment, the CEC can be impeached, the ECs can just be removed on a recommendation of the CEC. In fact, that was the argument made by Mr. Seshan in the Seshan case, saying that, look, I am preeminent, I can recommend his removal. So I stand differently from him. What we are saying is, once a judgment has come that all of you are on par, and we are trying to protect the entire litigation here before this constitutional bench is about protecting the election commission. You can't have a protected election commission if the election commissioners are also not given the same protection from removal that the CEC is given. He's just first among equal. It's like saying that the Chief Justice of India can be impeached, but the judges of the Supreme Court recommended. I'm drawing a parallel. I'm saying these are institutions which require protection. So the offices that are held within that institution require the same protection. He may be first among equals, but he's not different. That's what your lordships have said in session. So here, unless the government has a different view and accepts my interpretation, in which case I have to say nothing else. If your lordships reads 324(5) with the proviso, I'm grateful to Justice Rastogi, the proviso brings the Chief Election Commissioner in. The proviso does, the main provision does. And what does the proviso say? It gives him two protections. It says your process of removal will be the same as that of a judge, and your conditions will not be changed to disadvantage. Surely when the second proviso after that says provided further than what? Further than the proviso which just preceded you with a colon. I keep saying colon because Justice Arun Mishra's judgment in that Indore development places great emphasis on the colon in section 24(2) of the Rehabilitation Act and the importance about where the proviso fits. So I'm saying here you have a colon after 324(5) and you have a colon after the first proviso. So proviso 2 is stitched to proviso 1 and says impeachment conditions not to be changed to your disadvantage, further provided that for you, when you are going to exit, recommendation of CEC is required. That's the way I would interpret it.
Otherwise,
Yep.
you say that otherwise there is a vacuum in the second proviso.
Yes.
Because the procedure, what should be the procedure for removal?
Yes.
It is not actually specifically
Specified at
stated
all.
in the
I
second.
am most grateful.
Whereas in the first proviso,
Yes.
it's very
It's
specific.
very specific. Either we say it's a vacuum and then that vacuum has to be filled up, which has not been filled up in 72 years. Or there is no vacuum.
If it is a vacuum, then it is to be filled up.
Yes.
Or else the how it should be interpreted.
It should be. I'm most grateful. That perfectly sums up what I'm saying. In fact, I didn't have to waste 20 minutes. That 2 sentences sum it up. The second proviso is stitched to the first proviso. And therefore, the process of removal of the election commissioners has obviously to be on par with that of removing a chief election commissioner, because otherwise the other protection also goes. His conditions can be changed to his disadvantage. It's meaningless because across the constitution for civil servants, UPSC, judges, your lordship are given that protection that won't be changed to their disadvantage. How do you suddenly stop at the C's?
Or you can put it the other way around.
Yes.
The second proviso only put a mechanism how to put the things to motion.
Yes.
The process to be initiated by the Chief Election Commissioner.
Yes. Or is right.
Thereafter, the first proviso to follow.
Correct. Correct. That's exactly. That's also a way of looking. That is when you stitch these two provisos together. That's the only way it could possibly flow.
So the initiation will be by the Chief Election Commissioner.
Yes.
The second proviso is over.
Yes.
Then you fall into the first proviso.
Yes.
And the first proviso mechanism to follow for the purpose
Absolutely.
of taking a final call.
Absolutely.